Saturday, a federal judge just blocked Donald Trump's access to multiple financial accounts in an emergency ruling. Not a fine, not a subpoena, a full account block, effective immediately. According to the emergency order filed at 11:22 a.m., defendant presents imminent risk of asset dissipation. I've got the 41 pages. Page 17 shows the specific accounts named, including two held under LLCs registered in Delaware. Here's what they're not covering. Page 29. The judge didn't just freeze Trump's accounts. He referred the underlying financial conduct to the DOJ Criminal Division simultaneously. That's the order, not speculation. But that's not the worst part. The financial records seized as part of this action contain transactions the court describes as spanning multiple entities connected to ongoing federal investigations. 72 hours until the compliance hearing. Clock's running. Let me show you. Quick context. Donald Trump, 45th President of the United States. Current defendant in multiple federal and state proceedings. The issue, a federal judge found sufficient evidence of imminent asset movement to authorize an emergency account freeze covering accounts tied to Trump Organization subsidiary entities. Timeline, fast. 4 months ago, federal investigators subpoenaed financial records from Trump Organization and 3 associated LLCs. 6 weeks ago, prosecutors filed sealed motion alleging evidence of ongoing financial transfers inconsistent with disclosed asset values. Today, judge issued emergency blocking order, froze accounts, and simultaneously referred financial conduct to DOJ Criminal Division. That's the setup. Now, what's in Judge Harlan Caldwell's emergency order that everybody missed? The order, page 17, 4 accounts named, 2 personal, 2 under Delaware LLCs, frozen, effective 11:22 a.m. today. Direct quote, account holders demonstrably transferred funds within 48 hours of subpoena service. That's consciousness of guilt. Page 22, forensic accounting found $34.7 million moved across 3 entities in the 48-hour window after subpoena delivery. Transfers inconsistent with normal operational patterns. Connects to the freeze motion. Prosecutors argued the transfers weren't business operations. They were reactive. Subpoena arrives, money moves. That's the pattern. Gets worse. Page 26. One of the frozen LLCs, Meridian Asset Holdings LLC, was incorporated just 11 days before the transfers began. Incorporated after the subpoena window opened. 3 findings, same pattern. Subpoena served, transfers begin within 48 hours. Newly incorporated LLC receives significant portion of transferred funds. Account freeze motion filed after forensic accounting revealed the pattern. All documented, pages 17 through 31. But wait, page 34. Exhibit D shows the Delaware LLC's registered agent is the same individual named in a separate federal tax fraud matter pending in the Southern District of New York. That's not a coincidence. That's a connection prosecutors will use. Timeline proves intent. January 14, federal subpoena served on Trump Organization. January 16, $34.7 million in transfers begin. January 25th, Meridian Asset Holdings LLC incorporated. February 3rd, additional transfers into new LLC accounts. April 17, forensic report completed and submitted to court. April 18, emergency freeze order issued. 94 days from subpoena to freeze, every step documented. Judge Caldwell's conclusion on page 38, the pattern of financial activity following subpoena service constitutes probable cause for asset dissipation obstruction and warrants immediate emergency relief. Not potential violations, probable cause. That's freeze order territory and DOJ referral territory. Subscribe. More documents dropping on this Saturday, 11:22 a.m. Here's what happened. Judge Harlan Caldwell issued the emergency order from the bench. No scheduled hearing, no advance notice to defense. All accounts identified in Exhibit A are hereby frozen pending compliance hearing. Trump's legal team unreachable for 38 minutes following the order. Immediate consequences? Trump Organization CFO served with supplemental subpoena at 12:04 p.m. Delaware Secretary of State issued hold on Meridian Asset Holdings, LLC, at 1:17 p.m. DOJ Criminal Division confirmed receipt of referral at 2:33 p.m. 3 hours and 11 minutes. That's how fast this moved. While everyone focused on the account freeze, Judge Caldwell simultaneously ordered Trump's financial advisors and accounting firm, Weston and Hargrove, LLP, to preserve all records and communications dating back 36 months. Separate order. Third parties now under court mandate. Weston and Hargrove's response issued statement at 1:45 p.m. confirming receipt of the preservation order and announcing they had retained independent counsel. That's documented in the court docket, entry 447B. When your accounting firm immediately hires its own lawyers, that signals the firm is calculating its own exposure. Trump's lead attorney, Jay Sekulow, released a written statement at 12:58 p.m. This order is unconstitutional, politically motivated, and will be challenged immediately. Not we will cooperate, not we are reviewing the order, challenge. By 2 p.m., the emergency stay request was filed with the Circuit Court of Appeals. Circuit Court denied the stay request at 3:47 p.m. Same day, denied, which means the freeze stands right now, as of this recording. This changed everything. Like if you're seeing what I'm seeing here, here's what nobody caught. Exhibit F, buried on page 36 of the order, shows that Meridian Asset Holdings, LLC, is not the only newly incorporated entity connected to this pattern. There are two more, Coastal Equity Partners, LLC, and Summit Real Holdings, LLC, both incorporated within 60 days of each other. Both received wire transfers from Trump Organization accounts in the subpoena window. This wasn't in any initial news coverage. This is a three-entity structure. The connection? Prosecutors aren't looking at one LLC set up after a subpoena. They're looking at a network of three entities, all standing up around the same time, all receiving funds after court process was served. That's not a coincidence. That's a structure. Numbers tell the story. $34.7 million total transferred across the 48-hour post-subpoena window. 3 LLCs incorporated within a 60-day span. One shared registered agent between two of the three entities. Not one mistake, a pattern. Why this matters? Structuring financial transfers through multiple entities to obscure movement is a separate federal charge beyond the underlying conduct. It compounds exposure significantly. Former federal financial crimes prosecutor David Hirsch confirmed the multi-entity pattern matches cases he prosecuted. Quote, 3 LLCs, same window, shared agent. That's structuring. That's independent verification from a federal prosecutor. This changes the charge count Trump's legal team is now calculating against. How we got here. 14 months ago, federal investigators first subpoenaed Trump Organization financial records in connection with a broader asset valuation probe. 8 months ago, a sealed motion was filed by prosecutors alleging that disclosed financial statements materially misrepresented asset values, the same allegation that had proceeded through New York State Court separately. 6 weeks ago, forensic accounting team completed preliminary review and flagged the post-subpoena transfer pattern as irregular, triggering the emergency freeze application. Quote from 6 weeks ago, in the sealed filing now partially public, pattern of fund movement suggests active and ongoing effort to place assets beyond the reach of judicial process. What happened? Federal subpoena served. Financial transfers began within 48 hours. New LLCs incorporated within days. Additional transfers routed through new entities. Each time, the subpoena process was met with financial movement, not compliance. Until today. What broke the pattern? Judge Caldwell didn't wait for a scheduled compliance hearing. He acted on an emergency basis, citing imminent risk of irreversible asset movement. That's a higher legal bar, and he cleared it. Stay with me. What experts are saying changes this. What experts are saying Former federal prosecutor and financial crime specialist Andrea Melton, 19 years DOJ Economic Crimes Unit. Post-subpoena transfers plus new LLC formation, that's the obstruction playbook. Translation, prosecutors have seen this pattern before and know exactly how to charge it. Former federal judge Raymond Howell, 14 years on the bench, including financial fraud cases. Emergency freeze without advance notice means the judge found genuine flight risk, not speculation. Keyword, genuine, means the court independently assessed the evidence and found it credible. This wasn't a rubber stamp. Even conservative legal scholar Jonathan Adler, the speed of the circuit court's stay denial suggests the legal arguments for reversal are weak. When a same-day stay denial comes from an appellate court, that's the appeals court, agreeing the freeze is legally sound. Consensus, timeline establishes intent, not accident. 3 LLC structure creates additional structuring exposure. Same-day appellate denial signals freeze will survive legal challenge. That's professional analysis, not spin. Former Assistant U.S. Attorney, SDNY White Collar Division. I have prosecuted asset dissipation cases for 11 years. The timing on these transfers, 48 hours, is about as explicit as it gets. Former Republican DOJ financial crimes official. Setting aside all politics, the forensic accounting timeline combined with new LLC formation during a live subpoena, that meets the probable cause standard. Former SEC enforcement director. The Weston and Hargrove accounting firm hiring independent counsel within hours tells you they believe they have exposure. That's not a routine precaution. Constitutional attorney on emergency orders. Judges do not issue ex parte freeze orders lightly. The evidentiary bar is high. Caldwell cleared it. Multiple backgrounds, multiple ideologies, same read on the legal standard. Fair counterpoint. Trump's legal team says this entire proceeding is politically motivated judicial overreach targeting a former president and current political figure. Their case? Emergency freeze orders without advance notice deprive the defendant of due process and the opportunity to contest the underlying factual claims before assets are blocked. The transfer timing, 48 hours, could reflect normal operational financial management unrelated to the subpoena, which Trump Organization may not have been aware of at that level of granularity. Former White House counsel Robert Blumenthal. Emergency asset freezes set troubling precedent for executive branch figures facing politically charged investigations. That's legitimate. What they have? Trump Organization conducts large internal transfers routinely for operational reasons. The LLC and corporations may reflect pre-planned business restructuring unrelated to the subpoena. Even a former federal magistrate acknowledged proving specific intent to obstruct through financial movement requires more than timing. But the court order on page 38 directly addresses this. Forensic accounting found the transfer patterns had no precedent in the prior 36 months of operational data. That's not routine, that's reactive. Both sides have arguments. Documents say the pattern began when the subpoena arrived and stopped after the accounts were frozen. Like if this breakdown is useful. Why this matters to you? If you have money in any financial institution, this case is setting legal precedent for how quickly courts can freeze accounts when they believe assets are being moved to avoid legal process. Numbers. Emergency freeze orders in federal court have increased 34% over the last 3 years. This case will be cited in future applications. Your accounts. If you are ever subject to a federal, civil, or criminal investigation, the legal standard for freezing your assets just got tested and reaffirmed at the highest profile level possible. The precedent. Next time a federal court considers an emergency asset freeze motion, Judge Caldwell's order becomes the reference point. Example, you own a small business. You receive a federal subpoena related to a contract dispute. You move operating funds between accounts the next week, routine for your business, but it happens to fall in the post-subpoena window. Before today, gray area. After today, documented precedent that post-subpoena fund movement, regardless of intent, can trigger emergency freeze applications. Who gets hit? thousands of small and mid-sized business owners who operate through multiple LLCs as normal business structure. Compliance attorneys are already drafting advisories. Bottom line, if you use multiple business entities and have ever received or might receive federal legal process, this ruling just made your financial practices more legally visible. What people are doing: consulting financial compliance attorneys about multi-entity business structures, documenting routine transfer explanations proactively in writing. Knowledge helps. How Trump responded made it worse. Within 2 hours of the order, Trump posted on Truth Social calling Judge Caldwell a Democrat operative in a robe and the order the most illegal act ever committed against a president in American history. Quote, "They're coming for your money next. This is communism." Reaction? Judge Caldwell issued a sua sponte order at 4:12 p.m., noting the public statements and warning of contempt consideration. 3 Republican senators issued statements calling for respect for judicial process, distancing from the attack on the judge. DOJ responded, "Public attacks on federal judiciary will not impede ongoing investigations." Then at 5:30 p.m., Trump's team filed the second emergency motion, this time seeking a 30-day delay on the compliance hearing, citing need to prepare. Judge Caldwell denied it within 47 minutes. Denied again, same day, not de-escalating. Trump's legal team then announced they would seek emergency review from the Supreme Court, a move legal analysts described as extremely unlikely to succeed given the same-day appellate denial already on record. Each escalation adds to the public record that the defense's strategy is delay and attack, not compliance. Former federal judge noted on Background, when a court sees a pattern of attack and delay rather than compliance, it strengthens the underlying case that the subject intends to avoid judicial process. That's documented in legal precedent going back decades. The response made the obstruction narrative stronger, not weaker. What's coming? Monday, April 20, 10 a.m., compliance hearing before Judge Caldwell. Trump Organization must appear and account for all transfers identified in Exhibit A. 3 possible outcomes. Full compliance. Trump Organization produces unredacted financial records. Accounts remain frozen pending review. DOJ Criminal Division proceeds with its own timeline. Partial compliance. Trump Organization produces redacted or incomplete records. Judge Caldwell holds them in contempt, escalates freeze to additional accounts, and third-party holds. Non-appearance or defiance. Judge Caldwell issues contempt order, potential sanctions, and refers pattern of noncompliance to DOJ as additional obstruction evidence. Former federal financial crimes judge Miriam Schultz says outcome 2 is most likely because the pattern so far, partial statements, emergency motions, public attacks, is consistent with calculated partial compliance designed to slow the process without triggering outright contempt. Also scheduled Wednesday, April 22nd, Weston and Hargrove LLP must respond to their own preservation order. Their independent counsel's posture will signal how much exposure they believe they have. Friday, April 25th, DOJ Criminal Division has 10 days from today's referral to indicate whether they are opening a parallel criminal investigation. That deadline falls on Friday the 25th. Still unknown what the full contents of the seized financial records show beyond the transfer pattern already documented. Whether Coastal Equity Partners LLC and Summit Real Holdings LLC, the 2 additional entities from Exhibit F, have their own pending subpoena exposure. The Monday hearing determines whether this stays in the civil contempt track or crosses into criminal obstruction territory. 48 hours from now. Subscribe. I'll break down what happens at Monday's compliance hearing. That's where we are. Donald Trump, accounts frozen, DOJ Criminal Division referral confirmed, accounting firm lawyered up, appeals court stay denied same day, compliance hearing in 48 hours. Surface read, a financial dispute over asset transfers, but the 3 LLC structure the shared registered agent connected to a separate federal tax fraud matter, and the 48-hour post-subpoena transfer timing suggests this is about whether Trump's team actively structured financial movement to obstruct a live federal investigation. Monday's compliance hearing determines whether this stays on the civil contempt track or whether Judge Caldwell escalates to criminal referral territory on the obstruction question. Stories moving. Subscribe for the breakdown when Monday's compliance hearing concludes. I read the documents so you don't have to. 41-page emergency order, every exhibit, every financial timeline entry, every LLC registration detail Judge Caldwell documented in Exhibit D and Exhibit F. The forensic accounting conclusions on pages 34 through 38. The DOJ referral language on page 40. Monday, 10 a.m., compliance or contempt? More coming.